I would also implore us to move towards the front, even though we are few. Please, let's endeavor to move towards the front. Now, the first speaker I'll be calling up is Miss Sonuga. Please, let's have a round of applause to welcome our distinguished panelist, Eniola Sonuga, to the stage. Thank you. Secondly, I'll be inviting our second speaker for today, Mr. Prince Osisiadan, to the stage. Please, a round of applause for him. Thank you. We also have another speaker, Chief Joe Kiari Gadzama, SAN. He is not presently at the conference, but I will be presenting his paper for him. So a round of applause for me as well. Thank you. So I'll double as a speaker and a moderator for this session. Now we'll begin with the first speaker. I'll read out her short profile before she comes up to the stage to speak. I'll implore us to listen attentively, write down our questions if we have any, because there will be an opportunity for us to ask questions and make comments and recommendations as appropriate. Now, Eniola R. Sonuga is a lawyer specializing in international economic and trade law, a public policy advisor, and a passionate advocate for Africa's economic transformation. She serves as Chief Policy Advisor at Optima Policy, a Pan-African think tank, advancing evidence-based solutions for the continent's growth. A published author, Eniola has written extensively on the AFTA, ECOWAS, mineral policy, and African sovereign debt issues. She has spoken at high-level forums organized by UNECA, ECOWAS, GIZ, AIRESS, and AFI-ELN. She's a member of Chatham House and the Harvard Kennedy School Women Alumni Network, and has completed academic and executive programs at the University of Manchester, Harvard, MIT, Cornell, and Oxford. Please, with a rousing applause, let's invite Eniola Sonuga to deliver her paper. Thank you.
Thank you. Good morning, everyone. So my paper is titled Africa is Not for Sale. And it explores who really profits from infrastructure development agreements on the continent. So I'll start this way. When we think about regional integration, we think about economic advancement in Africa, infrastructure is the backbone of that, because we can't have regional integration, we can't have economic advancement if we don't have the infrastructure to support it. I'll give you some data. The African Development Bank, for example, tells us that Africa is 40% less productive than it should be because of our infrastructure deficits. And it puts the infrastructure deficits actually at about, I think, over $100 billion annually. So there's a lot of work to be done in plugging that gap to make sure that we have the infrastructure to enable us integrate and to enable us advance as a continent. So back to my example of the AFCFTA, if we were to have trade between Ghana and Nigeria, we need transport corridors, we need rail, we need digital infrastructure, we need even energy infrastructure. But the problem is, like I mentioned, there's a deficit in financing this infrastructure. And then the question then becomes, how does Africa finance the infrastructure development that it needs? If you look at the global example of how countries typically around the world finance the infrastructure, the World Bank data says that about 70% of infrastructure financing across the world comes from debt. And that poses a problem for Africa, because Africa has significant challenges accessing international capital markets to get financing to finance different projects, including infrastructure. And one of the reasons for this difficulty is sovereign credit ratings. So what's a sovereign credit rating? To put it in simple terms, a sovereign credit rating is an analysis or an assessment of your, to put it very simply, your ability to pay back a debt. So if I were to bring to the microeconomic level and I were to use myself as an example, if I said that I had a bad credit rating, that just simply means that I'm telling my potential creditors that if they borrow me money, I'm not likely to pay back. So what would happen is that if anyone, first of all, a lot of creditors will shy away from lending me money because they don't want me to default. But the ones who don't shy away would then lend to me, but at a very high price. So I will be paying a very high premium for financing. And this is exactly what's happening to African countries. So what happens is African countries borrow, but when they borrow, they pay much higher than other countries. And this, of course, is unsustainable. So we have debt sustainability issues, and then there's a debt trap. So what that means is that we borrow at a high price. We cannot service our debt properly. A lot of the debts, GDP to debt ratios or revenue to debt ratios of countries is very high. I believe where we are now, Ghana, it was 70% at a time, meaning that 70% of the revenue coming into Ghana was going into servicing debts. So to avoid defaulting on debt, a lot of countries then go and refinance. So they go and borrow again to service the debt, and this, causes a cycle of debt unsustainability. As it relates to infrastructure now, African countries are unable to adequately finance all the infrastructure development projects that they need. So I mentioned that the African Development Bank has stated that we need over $100 billion to build the infrastructure that is needed across the continent. And the global powers, so when I say the global powers, I mean the European Unions, the Chinas, the Russias, they're not oblivious to this fact. And they have stepped in to try to fill in this gap. But the question that we have to ask is, who does this favor? Who does the agreements, the initiatives, the interventions of these foreign powers, who does it favor? Does it favor African countries, or does it favor them? Excuse me. So to explore this topic, the paper assesses two case studies. The first is China's Belt and Road Initiative. So the Belt and Road Initiative is an initiative of China which pretty much focuses on developing infrastructure across the world. But the interesting thing about the Belt and Road Initiative is that they've sort of had a very special focus on Africa. And we need to ask ourselves why. At what cost does it come to us to engage in these interventions and these agreements with, initiatives like the Belt and Road Initiative? To give you some data, there are 54 countries in Africa. Out of the 54 countries, 53 are participating in this Belt and Road Initiative. But how often do we take a step back to look at the agreements that they're giving us? I'm sure we all know that global powers are competing with each other. So in response to China's influence, growing influence around the world and especially in Africa, other powers such as the European Union have also introduced their own initiatives in Africa. So the European Union introduced the Global Gateway Initiative, which is supposed to do the same thing, infrastructure developments across the world. But then again, the same trend we see it in Africa. They're focusing very specially on Africa. They pledged about 300 billion euros for infrastructure development across the world. And out of that 300 billion pledged for the whole world, half of it is pledged for Africa. So again, we have to ask ourselves why. What are they getting out of it? And what are we getting out of it? So to assess this, maybe we can do a comparative study of the two, Belt and Road Initiative and the Global Gateway Initiative, and then benchmark it on three indicators. So the first being the financing terms. When they borrow to us or when they finance our infrastructure projects, it's not for free, of course. So there's going to be interest rates. You're going to pay for that service. That's number one. There's going to be maturity periods. How long do you have to pay back this debt? And then there's grace periods. So if for example, they lend the money to build the infrastructure, and within the 20 years that you're supposed to pay back, you're unable to pay back as a country, what is the grace period? How long do they give you to sort out yourself? Content development, skills transfer, technology transfer. When they're coming into the continent to do all these infrastructure projects, how do they contribute to Africa? Do they bring all the foreign workers and come and give them all the jobs? Or do they, develop local content? We need about, I believe the last count, if I'm not getting my data wrong, is 25 million jobs annually to meet the growing workforce. We have a very young population in Africa. So do they contribute to this? Do they train the people on the ground? So those are the three metrics that we will be assessing. And then at the end of that, we're going to do a comparative analysis. If you pay very close attention to what's going on globally, you would find that there's almost shifting alliance amongst African countries to different global powers. So some countries are maintaining their alliance with the Western powers. They call them the Bretton Woods powers. You think of the United States, you think of the United Kingdom, you think of the European Union. And then others are shifting. For example, some of the ECOWAS countries that recently exited, Burkina Faso, Mali, Niger, shifting towards the East, not the West, the East, so China, Russia, many other countries. In fact, most countries in Africa actually are now aligning with China. So the analysis is to see, do they present different outcomes? Is there a benefit with shifting alliance to the West, or maintaining alliance with the West, or shifting to the East? Or are they giving us basically the same, the two different sides of the same coin? So we will do an analysis with that. So I'll start with the Belt and Road Initiative, which is China's initiative in Africa to develop infrastructure in Africa. With the Belt and Road Initiative, first of all, looking at the financing terms, they present it to the world and even to Africa. Now we mean it's supposed to be a partnership, so it's for development, so it's not going to be on the same terms as if Africa were going to go to the capital markets. And if you remember earlier on when I started speaking, I mentioned that Africa has a problem going to the capital markets or the international debt markets to get financing because of our sovereign credit ratings. So when we go there, we're borrowing at exorbitant prices, higher than other countries. So we want to know, are these termed by the Belt and Road Initiative of China, are they actually concessional, or is it just the same thing, as going to the international capital markets? In which case, it will not be sustainable for African countries. Well, looking at the data from some of the agreements, we can see that pretty much they're on commercial terms, so it doesn't really differ from what's attained in international capital markets. And there's a lot of debt on sustainability. So we see African countries defaulting. If you look at Zambia, for example, they defaulted on some of their Chinese loans. And then there was the issue of the Chinese government, or at least it was an institution. So I don't know what it is in Ghana, but in Nigeria, for example, when we had the PHCM before it was privatized, imagine China taking over, owning, the company that powers the whole of a country, of Nigeria. So these are very concerning terms. Especially given the track record of African countries, in defaulting in debt. In fact, when we look at the sovereign credit ratings of African countries, out of 54 are actually investment grade, meaning that only 2 countries can actually borrow from international markets at reasonable prices. So for the financing terms, it's very much commercial terms and pretty much very unsustainable in terms of debt management. Then when we look at the transparency of these contracts that the Chinese bring to Africa, I think compared to maybe some other global powers that are acting in the infrastructure sector in Africa, they're relatively more transparent because we are able to access the contracts. But I think when you compare it to multilateral agencies like the World Bank, you see that there's room for improvement. So we're not seeing very much a lot of the terms that we need to be seeing. In addition to that, some of the terms are not standard contractual terms. They very much favor the Chinese over Africa. And so we have an issue of transparency. And because there's an issue of transparency in these contracts, they're opaque, they're not widely available. People cannot see what their governments are actually entering into, so that parliaments, the people, civil society organizations can hold both their governments, the African government, as well as the foreign lenders accountable. So that's a very significant issue. And then thirdly, when we look at local content development, skills transfer, and technology transfer, that is another area where we have a significant problem. There have been many reports, and I'm sure that anyone who follows the news would see, of human rights abuses, poor working conditions in some of these Chinese facilities. In addition to that, the data actually initially from, I believe, up from 2009 upward to about 2018 showed that Chinese workers were the majority, they formed the majority of the personnel of the staff in all these infrastructure development projects in the sites, mining sites, construction sites. It was mostly Chinese workers. So they would bring their workers from China who would take on the managerial roles, the senior roles. And then, of course, if African nationals were to be employed, they would mostly be the artisans and some of the menial jobs. However, the data shows that shifted post-COVID, so post-2019. And now they've actually reduced the number of Chinese officials that come to the country, into the continent, for these project sites. However, that is not necessarily an altruistic decision. So it's not because they feel so magnanimous to give jobs to Africans. But, thank you. Okay, to give jobs to Africans, but it's more so because of post-COVID-19 and then dropping oil prices around the globe. So I'll move very quickly on from that, and I'll move to the European Union's Global Gateway Initiative. Well, in terms of the financing terms in the contracts, I will say that it's very much commercial again. So they rather, as opposed to the Chinese, which use the China Export-Import Bank, so that's public spending, the Europeans are actually using blended financing. So what that means is it's a lot of private financing. And a private investor is want to borrow on commercial terms. So it's also on sustainable debt because they have to do it at the same terms as international markets. And then for transparency, actually, interestingly from the research, Europe is actually much worse than the Chinese because practically none of the agreements are even available for assessment to see what it is. And then in terms of skills transfer, well, they do make some efforts, but I believe that a lot of the outlook of the Europeans is to benefit the companies, so the large European companies in Africa, the Siemens of this world, the BioNTechs, all the large corporations. So there's very little focus on African development. Now, to round up, the question is, what do we do about it? Do we blame the foreign powers? Personally, I'd say no. As a country, as a continent, as a bloc, you're going to do what is best for yourself. So it is for us as Africans to ask the tough questions and to negotiate better agreements that are fairer and actually benefits us. No one can do that for us. We have to do it for ourselves. Our institutions have to do it for ourselves, and our governments have to do it for ourselves. So one way that we could do this, for example, we have something called the African Legal Support Facility. This African Legal Support Facility was established under the African Development Bank, which of course is under the African Union. And this organization was established specifically for that purpose, to negotiate contracts to ensure fair outcomes. The question is, what are we doing with these organizations? How do we engage them better? As lawyers under the African Bar Association, how do we engage the African Legal Support Facility to ensure that we can be very well represented? So the voice of the people, the population, civil society organizations, and associations like the African Bar Association can engage with the African Legal Support Facility to, one, make sure that these contracts are fair, to make sure that they are transparent, to make sure they're sustainable, and to make sure that we have local content development so they don't just come, make their money and go back. And two, I think lastly, what I would say is also we need to look very, very closely again at the financing terms. There are also reports that some of these agreements have things like mineral offtake clauses. So if you're unable to pay, we will take your minerals. Some of them have assets. you transfer the assets. So I mentioned Zambia. The case with Zambia's power holding company. So if you're unable to pay, basically the power holding company will become the property of the Chinese. So imagine a continent where most of our major assets, our highways, our institutions, suddenly become under the ownership of the Chinese or the Russians or the Europeans. This is a problem, but these are the agreements that we are actually entering into. So that's my final charge. I would say for the African Bar Association, for us lawyers, for African governments, policymakers, we really need to make sure that we scrutinize these agreements that we're entering into. Yes, infrastructure development is important for us to be able to do pretty much anything that has to do with development, anything that has to do with integration. But the question is, at what cost and to whom? So thank you very much, ladies and gentlemen, for listening.
Please, a better round of applause for her. Thank you so much, Eniola Sonuga, for that insightful presentation. I hope we listened carefully and paid close attention, because there will be time for us to give our questions and recommendations or comments at the end of this session. To take us further, I would be introducing the next speaker for today. Our next speaker is Prince Osisi-Adan. Prince Osisi-Adan is a lawyer, engineer, and sustainability expert with experience across mining, oil and gas, construction, real estate, transport, banking, hospitality, tourism, and sports. He has previously worked with Anglo Gold Ashanti and Newmont Mining Corporation. He studied at Kwame Nkrumah University of Science and Technology, GIMPA, the University of Twente, Netherlands, and the University of Cambridge, United Kingdom. A member of the Ghana Bar Association and the Ghana Institution of Engineering, Prince is an ISO 1400 lead auditor and certified sustainability and climate risk professional. He is accredited by the Global Reporting Initiative, GRI, and the Global Association of Risk Professionals, GARP. He is also a GRI certified trainer in sustainability reporting disclosures. He is the CEO of Suka Africa Limited. Please, ladies and gentlemen, with a rousing applause, please let's welcome Prince Osisi-Adan for his presentation. Thank you.
Good morning, everyone. And I was telling the previous speaker that most of the problems she enumerated, actually my paper has a solution to it. So the solution was next to her, because she was talking about sovereign credit ratings, transparency, local content, and all that. Why do I say so? Now, one buzzword you hear through town every time is environment, social, and governance. Previously, when you're a lawyer and they approach you and say, can you do due diligence, whether it's an M&A or whether it's a merger and acquisition or any form of transaction, they say due diligence, or that you look at is it incorporated? Does it have a legal, is the organization a legal entity? Can it be sued? Or can it sue? The other thing is that the financial, so you need to bring in the accountants to say whether the financial status of the company is actually in shape, where that the other company will be interested. But now there's an upsurge. Anytime the request comes in, they will say, can you do ESG due diligence? And most law firms will come in, Prince, this one, can you come and help us? So that's why we are here. But see ESG not to be more of something of a burden, but as a tool for social sustainability development. Because when she spoke, access to funding is a problem. One key reason is sovereign credit rating, and the other thing is that environment and social issues are also upsurge. So most of the time, they put in a lot of clauses for us to adhere to. So my paper is actually looking at how we use due diligence as a tool for sustainable development and also for investment protection. So we realize that it's also a shield and a sword at a point. So if you look at Africa, the paradox is that we receive a lot of investment from the global north. And if, as of 2023, we're looking about $50 billion coming to Africa. Still, there are environmental issues to be dealt with. Still, communities are fighting. When you go to Niger Delta, there's a problem. Yesterday, one of my clients is a mining company. Galamseyers have engulfed, or illegal miners have engulfed their whole concession. They can't mine. These things continue to be an upset. Now, if you look at a new form of barrier for African organizations to access funding from the West. So apart from the sovereign credit rating she was talking about, now the question is that this is another layer. You need to pass that test before the money will be disbursed. But if you look at it, in reality, it comes in two ways when ESG is into the fore. It could help you to be able to, if you incorporate it better, your return of investment is likely to increase because you're not going to be fined on environmental degradation. You are not going to have community unrest because the moment you are in operation, you are in tune with your regulators, you're in tune with your communities. But the risk is that if you don't take it serious, you cannot access funding. So any funding now in modern times they are talking about, ESG, there's a component. Can you produce this? Do you have an environmental permit? Do you have even an ESG officer for the operations? Then litigation. If you don't take it serious, mitigation will come up. Because if there's community unrest and they stop your operations, you are now going to the government and saying that my investment must be protected. So litigation, then reputation. Because if you look at the way, you don't want to be in the news. Shell now has suffered so much in Nigeria. If you look at other companies globally, they continue to suffer. ExxonMobil has also not been an exception to that kind of negative reportage. And the amount of money you need to invest to be able to save your image, you're better off to incorporate ESG matters into whatever you do. So if you look at how ESG metamorphose in terms of helping everybody to do business, it has now moved away from being a soft law to a hard one. So it's now binding. How does it transcend into the normal day operation? It comes in two forms. Investment treaties. So now when you look at bilateral agreements, you could see that the fact that you need to, as an investor, you need to ensure that you protect the environment and also the community you interface. You make sure you protect their interests. It's a key thing. So if you look at Morocco and Nigeria, they have a bilateral relationship. Enshrined in it, you could see these provisions. After investment protocol, these are key things that when you go in there, you realize that protection of environment, human rights issues are all embedded in the protocols. Then corporate governance. If you are familiar with Nigeria, the Nigerian corporate governance code is very heavy on that. The Ken 4 in South Africa. Ghana, we are not left out. Even our company law also take care of. But do you know the interesting thing? The fiduciary duties of directors has been expanded. When you read these documents closely, to include environment and social and governance issues. So even in Ghana now, our new EPA Act, the moment your company is convicted, the directors or officers, the controlling minds of the business, they are automatically convicted. You can only, the burden now shifts to you to prove that you were diligent. Do you want to waste time and prove that? That's a question to be answered. Even in arbitral jurisprudence, it's now on the upsurge. Because when it comes to claims, arbitrators now factor in. So looking at a mining company in the community, they want to test what are the provisions or the safeguards that you put in place to address environment and social issues? So if the community come up, now they will look at this and factor into the claims that they need to award. Then one upside is disclosures. Everywhere you pass, they say you need to disclose your performance. Whether it's the EU, when you are selling to the EU, you need to disclose. When you come to the stock exchange, in Johannesburg Stock Exchange is there. You need to disclose your environment and social and governance performance. Ghana, we are not in isolation. So if you look at even the fact that you need to disclose your performance, if you don't take it serious, how do you disclose your performance? So these 4 areas makes, when it comes to the legal dimension of ESG due diligence gradually becoming mandatory. So it serves as also a shield for investors, because the investors will tell you that they want to put in those provisions so that the investee company on that side, you make sure that you take environment and social and governance issues serious, because they don't want to come and put money into your organization. The next day, that investment is stalled. So maybe there's an operation in Nigeria, or I'll use Ghana because we are in Ghana. So there's an operation in Ghana, now there's a community unrest because you're not taking environmental issues serious. So that investment needs to stall. So to avoid that, they will try to enshrine in the agreement with you, mostly the master lending agreement with you, that you need to make sure that environment, social, and governance issues are taken seriously. To the investee company or the host country where that investment sits, you also have, it's a sword for you, because it's a nice way to also tell the company that the operations that you are funding must make sure that it upholds the environment and social and governance laws of my country, and you need to comply with it. So it's also a shield and a sword at the same time. Then when it comes to the way we can implement it, so when it comes to the practical way ESG due diligence could happen, there are 5 ways. The pre-investment assessment, that's why they will come and tell you that I want an environmental impact assessment. Have you done stakeholder engagement? If you look at it, they will tell you, can you look at human rights issues for me? How are you going to deal with human rights? When it moves to the next stage of the contracting structuring, you could see there are also provisions in the contracting structuring. They will tell you that you always need to maintain an environmental permit during the subsistence of this agreement. You need to have an environment and social and governance issue. Let me give you a practical example. A company in the EU that I work with, they wanted to work with a Ghanaian company that has operations in Ghana, Kenya, and Nigeria. The key question is that because of the European sustainability standards, and now they need to come back and do a lot of due diligence and ensure that this company complies with, they wanted to back off. So in the agreement process, they are saying they don't want to invest again because they don't want to spend a lot of time complying with those regulations. The antidote to that was that, can they maintain an environment and social or governance certification? So what we went for is that throughout the subsistence of the agreement, the company in 2-3 years should always have an ISO 14001 certification. Why did I say in the 3rd year? Because the investee company that they are dealing with also don't have the financial muscles to go for the certification. So as a lawyer, that's the thinking frame you should be in. Although you are working for this one, you also need to think about our African companies, how we position it. So at the end of the day, 3 years, they will have been liquid enough because of the contract regime, the amount of money being paid by the investor to be able to go for the certification. So that's one way you need to think about it. Then the financing alignment. We used not to have green bonds. Now they are green bonds. They are social bonds. Where money is given to you, but it's ring fence. The word is ring fence. Where you need to use for certain specific environment and social interventions. The other one is compliance monitoring. They will tell you, can you submit your ESG report to us? Or they will always commission a third-party certification. Later this, in November, I had to spend my whole time doing forestry steward cancel certification because somebody is saying that I'm doing an afforestation project. The people financing says that you need to maintain that certification, so I need to spend my time doing that. So these are some of the things coming up. Then dispute prevention. You need to now look at our own alternative dispute resolution tools. Arbitration, you start from mediation, arbitration, to incorporate, to make sure that everybody is happy at the end of the day. Then, these are examples of where people didn't take ESG seriously. So, Bywater Gulf and Tanzania, it was a PPP that collapsed because they failed to do stakeholder engagement and they failed to also consider affordability of what they were delivering to the Tanzanian people. So it failed. In Zambia and Tanzania, most of they are having a lot of regulatory issues, especially with mining companies, because of what? Transparency and what the first speaker spoke about, local content failure. Because you cannot export everything from your home country and dump it into the home country. So what needs to be done is that promotion of local content. But let's look at the positives. If you look at the 600 million financing in Kenya, they comply with the IFC performance standard. They demonstrated that they will comply with it. On that basis, there was a disbursement. Then, South Africa, if you look at, there's an investment about 20 billion going into South Africa. But if you look at the procurement process, in terms of the procurement process, local content and all the materials also being bought must also be sustainable. Now, as Africans, what do we need to do? We need to move away from rule takers to rule shapers. So on the continent, you could see that the after investment protocol will balance what an investor needs and what an investee company needs. So what happens is that now there are provisions on environment and social and governance issues, and even on human rights, even on local content. Then, from the after regime, there's also ECOWAS, the regional framework, and SADC from the South Africans. These frameworks has components when it comes to environment and social and governance to make sure that you, the investor, you are protected. Also, the host country is also protected because in terms of environment and governance issues are dealt with. But that has not stopped because at the national level, there are laws. So Nigeria has sustainable banking principles. Ghana has sustainable banking principles. If you go to Kenya, they also have sustainable banking principles. And somebody will say that, why the focus on the banking sector? Because everybody will go for money, and that's where you need to put the control. That's why the financial sector is being greened always. Then, some of the complexities and the problems that undermine this kind of regime. The first one is that as Africans, we lack capacity to even interpret environment and social and governance information that are put out by companies. So Shell publishes their sustainability report. Have you taken time to even interrogate it? That the numbers they are putting out, is that correct? Then external standards. So we are always consuming standards. If you consume, it doesn't work for you. But it's good that we've now started looking at retooling these standards to work for us. Then the risk of the new conditionality, as I mentioned. Now the new condition is that before I give you money, you need to make sure that you comply with ESG matters. Now let's look at my recommendations for everyone leaving this room. Is that if you look at it, the first one is that you need to build capacity. If you are lawyers, you need to create a new practice, ESG practice in your law firm. Because if you don't do that, when these things come up, you struggle to do it. When you put the lawyers there, don't leave them just like that. You need to build capacity. Because sometimes when you go into meetings, the things are not straightforward like people think. When it comes to multilateral agreements, we should be able to ensure that these things, we need to advocate that these ones, they are amendments incorporating ESG parameters into it. Then we need to have local frameworks to be able to deal with that. Then when it comes to We need to advocate for reforms, especially with laws, because if you look at Ghana now, as I told you, now in Ghana, if your company is convicted, if you're a director or a controlling mind, automatically you are convicted. So my last statement to you is that if you look at the ESG matters, it has moved away from being just a burden to a legal necessity. As lawyers, we need to move away from being transactional facilitators, but we need to start thinking about being architects of sustainable investment by implementing some of the things that we've discussed this morning. Thank you.
Please, another round of applause for him. Thank you so much, sir, for your insightful presentation. We've been greatly enlightened. I hope we've also been taking down our questions and noting our thoughts and recommendations, because there'll be time for you to do that at the end of this session. To take us further in this session, I'll be inviting the next speaker. The next speaker is Chief Joe Kiari Gadzama, Senior Advocate of Nigeria. Chief Joe Kiari Gadzama took silk in the year 1998. He served on the Infrastructure Concession Regulatory Commission, ICRC, in Nigeria. With LLM degree in Energy and Natural Resources Law and Policy, he is currently pursuing a PhD at the same institution, a chartered arbitrator and fellow of the Chartered Institute of Arbitrators, United Kingdom, and the Nigerian Institute of Chartered Arbitrators. Chief Joe Kiari Gadzama, Senior Advocate of Nigeria, is listed in Who is Who Legal as an arbitration expert. He has held numerous leadership positions and recognitions across several professional bodies over the years. In 2015, he was recognized by the Intercontinental Finance Magazine, ICFM, as one of the 500 leading lawyers in the world. Chief Joe Kiari Gadzama, Senior Advocate of Nigeria, is a life member of the Governing Council of the African Bar Association and a life member of the Nigerian Body of Benchers and a member of its Appointments Committee. Please, with a round of applause, may we welcome Chief Joe Kiari Gadzama. Thank you. At this point, I'll inform us that Chief Joe Kiari Gadzama is unavoidably absent, but I will be presenting his paper on his behalf. My name is Onyekachi Eluwa, and I'm a legal practitioner from Nigeria, and I am an associate at the law firm of J.K. Gadzama, LLP. I'm here to present a paper on behalf of Chief Joe Kiari Gadzama, Senior Advocate of Nigeria, the founding principal partner of the law firm of J.K. Gadzama, LLP, who is designated as one of the speakers on this panel. He is unavoidably absent at this conference, but he sends his best wishes for successful deliberations at this conference. His paper is titled Free, Prior, and Informed Consent, FPIC, in Mining Deals in Africa, a Myth or Achievable Standard for Indigenous Communities. The paper aims to discuss the FPIC principle in the context of mining deals in Africa, in order to answer the question whether the FPIC principle is a myth or an achievable standard for indigenous communities. The paper examines whether the FPIC principle functions as a genuine safeguard for indigenous communities, or if it merely serves as a legitimizing myth for ongoing extractive exploitation across the African continent. The paper further highlights the level of implementation of the FPIC principle across selected African countries, It discusses the challenges which result in the practical failures of the FPIC in Africa, and it makes recommendations for the effective implementation in Africa. Across many parts of Africa, the extraction of solid minerals has brought significant harm to indigenous communities. These mining projects often move forward without informing affected populations or securing their consent. As a result, large-scale mining has become closely associated with land dispossession, environmental degradation, and the systematic erosion of community rights. In response to these persistent injustices, the principle of free, prior, and informed consent, which is FPIC, was introduced as a safeguard intended to protect indigenous people by ensuring that they have the right to make informed decisions about projects that impact them. Now, free, prior, and informed consent stands as a fundamental principle within the realm of indigenous rights, designed to ensure that indigenous communities have the right to give or withhold consent to projects that affect their lands, territories, or resources. This principle is particularly crucial in the context of extractive industries, such as mining, which often have significant impacts on the environment and the livelihoods of local communities. Some international and African regional instruments support this principle. However, its practical application within the African mining sector remains a subject of considerable challenge. Now, the FPIC has been defined as the right of indigenous people to give or withhold their consents for any action that would affect their lands, territories, or rights. It is a right that requires proponents of projects to consult with and obtain the consent of indigenous people before commencing activities that may affect their rights and interests. The FPIC principle originates from the right to self-determination. The right to self-determination refers to the right of people to freely determine their political status and freely pursue their economic, social, and cultural development. Human beings, individually and as groups, have an equal entitlement to be in control of their own destinies and to shape their own futures, and to live within governing institutional systems that are accordingly designed to reflect this entitlement. This right to self-determination recognizes that indigenous people must be meaningfully involved in decisions and consulted regarding any policies or developments that directly impact their lives, their lands, or their resources. Now, the acronym, as I've said before, FPIC, stands for Free, Prior, and Informed Consent. And these individual words form the elements of the principle. The word free means that the consent of indigenous people should not be given under any form of force, duress, or threats. It implies that no coercion, intimidation, bribe, or manipulation whatsoever should be involved. The word prior, as it literally means, indicates that communities must be provided with comprehensive information regarding proposed activities and must have ample time to review same before they begin. Now, the word informed means that the information shared must be thorough, highlighting both the potential benefits and risks associated with the activity and delivered in a manner that is culturally appropriate and easily understood by the community. The word consent means that the indigenous community holds the authority to approve or reject a project, both prior to its initiation and throughout its duration. I will give a brief overview of the legal and policy instruments that support the FPIC principle. Now, these instruments include international instruments, and African regional instruments. Some of the international instruments include the International Labour Organization's Indigenous and Tribal Peoples Convention, known as the ILO Convention 169. We also have the United Nations Declaration on the Rights of Indigenous People, known as the acronym UNDRIP. We also have the International Covenant on Civil and Political Rights, the ICCPR. Another international instrument is the International Covenant on Economic, Social, and Cultural Rights, which is the ICESR. We also have some African regional instruments which support this principle, and they include the African Charter on Human and People's Rights, the African Mining Vision, and the Economic Community of West African States, which is ECOWAS Directive on the Harmonization of Guiding Principles and Policies in the Mining Sector. The paper includes a lot more detail on the specific provisions of these legal and policy instruments. So I won't be going into the details of the sections and the particular articles which provide for the right to self-determination and the principle of FPIC. I will now move to highlight the extent of implementation of the FPIC principle in selected African countries. Now, research in the area of mineral resource governance across Africa shows that there are a number of troubling patterns across African countries. A widespread issue is that indigenous people and local communities impacted by mining activities do not receive sufficient protection. In numerous cases, the enforcement of the FPIC principle remains weak and inconsistent, resulting in tensions and disputes between extractive companies and local populations. Moreover, there is a widespread absence of effective frameworks to guarantee a fair distribution of mining-related benefits to the community most directly affected. Now, the paper also highlights in more detail some of the country-specific issues in relation to the implementation of the FPIC in some African countries, such as South Africa, the Democratic Republic of Congo, Kenya, Ghana, and Nigeria. So due to time constraints, I will not go into the details of the implementation in these countries. Now, I will highlight some of the major challenges to the implementation of the FPIC in Africa. Firstly, we have the challenge of state-corporate collusion arising from prioritization of foreign investment over community rights. So this simply means that the governments sometimes collude with the multinational mining companies because they prioritize revenue generation over the protection of their indigenous communities. African governments, often burdened by debt or seeking to boost their economies, may enter into agreements with mining companies that are not transparent and do not adequately protect the rights of affected communities. This can manifest in various ways, such as fast-tracking project approvals without prior environmental and social impact assessments, or granting concessions in areas traditionally occupied by indigenous people. Excuse me. Now, many African governments view foreign direct investment in the mining sector as a driver of economic as a driver of economic growth and development. Thank you. However, while these benefits are important for national development, they often come at the expense of local communities, particularly indigenous people. So on this point, it simply states that African governments prioritize economic development and prioritize revenue generation over the well-being of their communities. Now, another challenge includes poor literacy, awareness, and capacity in some communities. In many instances, indigenous communities are often geographically isolated, and so they are poorly literate, they lack proper awareness, and they lack adequate capacity. We also have the problem of weak enforcement mechanisms also present in these communities. So from the foregoing, it is clear that the level of practical implementation of the FPIC principle in Africa varies from one country to the other, and there is room for improvement. Okay, thank you. Bridging the gap between the theoretical recognition and meaningful realization of the FPIC principle requires a coordinated multi-stakeholder strategy as it demands action from governments, industry actors, civil society, and indigenous communities alike. Now, some of the major recommendations are as follows. Firstly, African governments must strike a balance between the need for protection of indigenous communities and the economic need for foreign direct investments. African governments must not sacrifice their communities at the expense of economic development. Secondly, African countries must prioritize the reform and reinforcement of their national legal and policy frameworks on mining in order to promote the development and implementation of clear, comprehensive legal and policy instruments that give full effect to the FPIC principle. In essence, African governments must reform their laws, and if they have existing laws which incorporate the FPIC principle, these laws should be reinforced. Thirdly, governments must ensure transparency and must monitor compliance through relevant agencies. We all know that governments have relevant agencies in the mining sector. These agencies must be strengthened to ensure transparency and to monitor compliance. Fourthly, there must be proper structuring and documentation of mining project agreements in order to eliminate uncertainty and ensure accountability. Additionally, capacity building for indigenous communities must be prioritized to ensure that community members make informed and meaningful decisions. Governments should invest in the capacity of communities through access to reliable technical expertise, legal support, and financial resources. Furthermore, non-governmental organizations, NGOs, and civil society organizations, CSOs, can contribute through advocacy for legal reform, pursuing strategic litigation, and grassroots mobilization. As I conclude, I must note that effective implementation of the principle necessitates acknowledging and addressing the inherent power imbalances between indigenous communities, governments, and multinational corporations. As we earlier said, most of these indigenous communities lack capacity, they lack technical, legal, and financial resources, and this creates a power imbalance between the communities, the governments, and these multinational organizations. Ultimately, the FPIC principle requires a commitment to ensuring that indigenous communities consent fully and benefit equitably from the resource extraction. The theme of this conference, as we have been discussing since yesterday, is foreign interests, since the week began, is foreign interests in Africa, exploitation or investment. And this topic aims to enlighten us on the fact that FPIC helps to promote equitable mining practices and ensure that foreign interests and foreign participation in Africa are properly channeled towards investment and not exploitation. So, by genuinely empowering communities and respecting their rights, FPIC can transform from a contested concept into an achievable standard for justice and sustainable development in Africa's mining sector. Thank you for your attention. So at this juncture, I'll be giving participants the opportunity to ask questions or to make comments. So please, if you have a question, I can see one hand up. If you have a question in the comments, can you raise your hand? Okay, I've seen 2 persons. So please, can you give the mic to...
Thank you. Thank you. Hello. Thank you. Thank you very much. Julius Patamian, Ghana Bar Association. Congratulations to the presenters. They are very youthful and they presented so well. If your name is Osisi Adine, what more can you do than build houses and build capacities? Anyway, we are proud of you. To the first presenter, you made mention of the fact that the Chinese are not being altruistic. If post-COVID, they are not now bringing down their managers and the rest. So in your view, marrying it to what Osisi Adine said, that it does appear the Europeans are very hard on the ESGs and the rest. Does it also mean, one, I want to know, in your view, why the decrease in numbers in terms of their management and the people they bring here? What accounts for that? And is it that they are also not minded of the ESGs, that's why their loans appear easier to get? And in your view, is it a bad thing to do business with the Chinese when we get to know that accessing their loans is even easier and it appears their terms are more reasonable to us? Or you still think that in their dealings, they are not altruistic? So you refer to maybe Chinua Achebe saying that the people came very quietly and peaceable, and they put a knife on the things that unite us, and things we are falling apart. Is that your view? And also, to the last presenter, on behalf of Chief SAN, you make mention, there's this allusion that anything large scale is problematic. I'm happy to disappoint you in Ghana here. The problem you are having here is not about large scale mining. The problem you are having, an existential threat to us, it's not about informed consent of the indigenous people. It is our indigenous people who are partaking in the small-scale destruction of the water we drink, of the land that today our cocoyam and the rest are now having heavy metal poisoning residues. So, sorry to disappoint you of the Ghanaian situation. Maybe that may be in the Niger Delta or something about Nigeria. So, country-specific. In this case, for Ghana, seeing that your paper, for what is happening on the ground right now, is different with the Ghanaian situation, what do you think accounts for indigenous people here partaking in the wanton destruction of our very environment, for which the chiefs who were the custodians of the land seems to be unconcerned, and these things are going on? Because though the minerals are vested in the president on behalf of the people, the lands belong to the chiefs, and they are custodians of it. So how do you navigate this dichotomy? And then lastly, I want to ask, with your ESG, we are very hard on the corporate institutions. And once again, we think they should do the needful. If they get it wrong, the directors are held liable. I'm very happy with that. So with our governments who are sponsoring this wanton destruction of our environments, how do we hold them accountable beyond elections? Thank you.
All right.
Okay, please let's answer the first question.
All right, thank you so much for your question. Very multifaceted. Let me start with, I think that was the last part about, if the Chinese are giving us loans that seem favorable, do we go ahead with it? From my perspective, I think it's the Chinese loans to me are almost like a Trojan horse. Why do I say so? It comes in a nice package, but inside there's all sorts of things. So when you look at the terms that are publicized, that are put out there, remember I mentioned during my presentation that there's a lack of transparency, so we don't really see the full picture. But upon the data that is available, upon assessing it, we see that there's some terms that are not very favorable to Africa. I think, first of all, the financing terms on their own are not necessarily favorable. They're not on concessional terms. So it doesn't really allow for debt sustainability. We're still borrowing at a very high price. They're still financing infrastructure development for us at a very high price. But then when you look at the subtle terms of some of these agreements, I give an example of Zambia. You have an agreement where they're going to build infrastructure for you. And then at the end of the day, when they build the infrastructure for you and it's time to, finance the debts that you owe for that infrastructure, you're not able to do it. And you have clauses where a foreign power is taking over your state facilities. Is very problematic, because can you imagine an African country where a foreign power is owning or having a majority ownership of a state-owned assets? First of all, to me, it's embarrassing, and it's also very, should I say, risky, politically, geopolitically, and also financially for the country. So for me, I would say it's not necessarily that they are giving better deals, which is why a lot of African countries are moving towards them. It's more so that it's accessible and it's what African countries can get, right? But the thing is, I'm also not saying that African countries should not enter into these agreements, should not participate in the Belt and Road Initiative. We should, absolutely. But the question is, are we taking our time to negotiate these contracts properly? You can enter into a contract. It's left for the two parties to negotiate it and come to an agreement of what will favor the both of them to the best of their ability. But that's not what we see in Africa. It's very much lopsided in favor of the foreign powers. So we need to take a step back as African countries. Yes, we need infrastructure to be developed. Yes, enter into some of these Belt and Road Initiatives with China, the GGI with Europe. But we need to be very careful about the terms of the contract that we're entering into. We don't, to my understanding, we don't hold ourselves accountable. We don't hold the Chinese. If you go somewhere and they just accept terms, any term that you give them, they don't, leverage, the advantages they have. They just accept any terms. Of course, the Chinese are going to push to see how far they can get to benefit themselves. So we also need to defend ourselves. We also need to look at the contract and be bold enough to say, we don't want this. This is what we want. And my opinion, this is my personal opinion, is that if we do that, I think the Chinese will still very much be interested in financing projects in Africa. It's just a matter of proper negotiation of these contracts. And then the last point about the altruistic intention of the Chinese, well, I think the reason why that number, went down while there were fewer Chinese workers coming in was, like I mentioned, it was a mix of factors. First of all, it was the post-COVID crisis. So, of course, China was heavily affected. Africa was actually projected to be very heavily affected. So that led to pullback of a lot of foreign personnel staff. And then there was also, the global financial crisis that followed the COVID-19 pandemic. So these were some of the factors that led. And of course, a redirection of the BRI objectives or their outlook after the pandemic. So these are some of the factors that led to the decrease in Chinese workers in infrastructure projects, not necessarily, a love for Africa or a desire to build local development content. Thank you.
On illegal mining, there's one simple answer. Lack of political will. Because there's nothing that can deal with illegal mining than political will. And government upon governments have failed to do so. Because if you look at the Act, and the Act says that if a company is convicted, and the directors and the controlling minds of the business will be convicted, where these illegal mining are happening, somebody holds a mining lease. And that mining lease is always given to a company that has shareholders and have directors. So it's very simple. So if you have a mining lease and there's illegal mining and the environmental and social practices are bad, what needs to happen? The shareholders, the directors, and the key officers of the company could easily be prosecuted. Also, these illegal mining are happening in communities. You have a chief. And we know in an African context, you cannot access a land without going through the traditional authorities. So they are all there, we know them. And to disappoint you more, yesterday, the mining firm I went to, there are people from Niger, Burkina Faso, who have taken over a pit, and they are even using cyanide to mine gold. So they called EPA, the Minerals Commission, to come in there. But the power is with them. Because another thing is that if you go to the EPA boss's home constituency, the water treatment plant there has been shut down. What are we doing? It's purely political will. So if the political will is there, illegal mining will not survive. Because from a legal perspective, there's a legal tool that we can use because the law is clear. If your company is convicted, automatically directors of the companies and officers of the companies are so what are we holding back? So that's my simple answer to illegal mining.
Thank you so much to our speakers for answering that question. I think the last speaker has already addressed parts of your question to me on the situation of Ghana concerning the indigenous persons themselves exploiting their own environments, so which is part of illegal mining. However, I believe that the major solution to that is enforcement mechanisms. I believe that Ghana has a ministry saddled with the responsibility of mineral governance, the governance of solid minerals, and there should be agencies, which I would not personally know the particular agencies, but for my country, I can list the agencies which are saddled with different responsibilities concerning solid minerals. Now, these agencies have supervisory roles over communities. The chiefs themselves at the local level have a political and an executive role too, to steward their communities, right? So that is also a problem in mining, which I mentioned, on weak enforcement mechanisms. The laws are there on the what you can do and what you cannot do, what warrants, what results in a crime and what does not. So the basic solution to that is strengthening the enforcement mechanisms. There are already agencies who are supposed to look into that. And that's why we're saying Ghana has the laws. Ghana has extractive transparency initiative and all of that. But what we need is the enforcement of these laws and policies. Thank you. So because we are very pressed for time, I've seen someone who was raising up his hand earlier. We'll just take 2 more questions and round up the session. So please, I saw one hand at the back. Are you ready to have your question now? Sir, you can go ahead. And then I have someone who was raising up his hand here. So we'll just take both questions at the same time, and then the speakers will answer them all, and we'll round up the session so that we can go on tea break. Thank you.
All right, thank you so much. We appreciate the leadership of AFBA. And at this level, we also appreciate the presenters, the resource persons, for your input. But I want to look at it from this perspective as per issue of mining. Virtually, both from the national level, that is at the state of country, at the level of countries, or at the continental level, or at the international level, we have laws guiding the issue of mining. But the major problem, because ordinarily, before you embark on mining, first you are supposed to go and seek the consent of the community or the landowner, as the case may be. Now, upon obtaining this consent, but there are so many things surrounded around the issue of consent. Sometimes you see that some companies will go and forge the signatures of community leaders or traditional leaders, and then go to the mining cadastral office, process and obtain license, a mining license. I'll give you an example. In Nigeria, as we speak now, about 4 communities, one company had obtained mining license to mine lithium. And this, we are talking about kilometers. So all of these communities, one person has obtained license without even coming down to the community itself. Then most of these things are perpetrated with us. We aid such acts, we Africans. Now, my major concern is that at this platform, AFBA, we've come up with a very fantastic thing. That is foreign interest in Africa. Is it an exploitation or investment? To an extent, the idea of foreign interest ordinarily is meant to be investment. But you discover that within our leaders, from the various countries, and then coming down to the communities too, we are being used as instrument of exploiting ourselves. Going further, upon obtaining consent, how many times do most of these mining companies obtain environmental impact assessment? How many times? Most of these mining companies don't obtain environmental impact assessment at all. It's a key factor. There's no law, there's no country. If you go to Nigeria, where I come from, it will tell you that, look, before you embark on mining, you must obtain environmental impact assessment. We've had discussion because my state, particularly my villages, my own community, we have a lot of minerals. You can find gold there. You have lithium there. You know, but in all this, I took my time, had discussion, conversation with the Commissioner for Environment. He keyed into the idea after exposing the loss onto him. He keyed into the idea, but what happened? After writing, he just took over, had meetings with these people, with the foreigners, with the investors, and then eventually, that goes. So, now that is one. 2, going forward again, do we also take our time to ensure that we implement the law in terms of obtaining CDA? That is Community Development Agreement. Because there is no way that you go into mining without having Community Development Agreement. And then finally, the law is also very clear that we are expected that if a mining company is after the mining activities, before you leave, you are supposed to do what we call reclamation. How many of our mining sites within Africa have been reclaimed? Now, this morning, before coming here, I was watching one of these guys from the hotel room. I was watching on Ghana television, one of the channels.
Oh, sir, please,
now, they have this eastern region.
Excuse me, sir. Please, can you shorten your... It has taken a long time and we have to close. Yes, just shorten your contribution and question, please. Thank you.
I'm not asking question, I'm contributing now.
You asked a question and you're making a contribution now.
Thank you. So now moving forward is that as we speak now, most of our environments have been affected and it's even affecting our own health. Now here, there's a community known as, in Ghana here, is it Nyanyoa or Krodua? Now, Galamsey mining site also, these are issues within Ghana here. Even we've seen that cocoa here has been affected. The food we eat, because whatever, after mining, once the spill of it goes into the streams, it has a way of affecting our own health. So these are things, what I'm driving at is that AFBA should use this as a platform to reach out to the leadership of each country to see that instead of just allowing this mining or extracting these minerals, taking them out of the country, can also find a way of talking to the leadership and make sure that we process some of the materials, some of these minerals here in Africa, then we now only export the finished products so that we can create employment here in Africa and also expand that sector of living. Thank you.
Thank you so much, sir. We're so grateful. We have just one last question. Let's take out the last question so the speakers can respond. Please, can you give him the microphone, please?
Good morning, speakers, and good morning, delegates. My name is Tabji Simon from Nigeria, and I'm an associate at JK Gadzama LLP as well. So Ms. Kachi is my colleague. In my case, I will be making a comment, not a question, actually. I completely agree with the submissions of Ms. Eniola on construction and Ms. Kachi on mining. I appreciate their work and their submissions. But by a little way of addition to what they have already said, I feel that looking at construction and mining with the focus of the central theme of the conference, which we've been deliberating on since on Monday, I feel we have to also agree that mining or construction, as the case may be, is a business enterprise. So be it a business enterprise controlled by individuals or by foreign governments, we have to understand that businessmen, whether in public or corporations or private enterprises, have at the back of their business needs to maximize profit. So if that is the case, I think we cannot continually complain about exploitation if we do not control the production of these resources. Now, most of the things that are being mined in Africa or the construction in Africa, if it is left to the African people, they would not even know that they are living on pool of wealth, uranium, crude oil, etc., gold, mention a few. So we have to have the control of these mineral resources, especially how they are being produced and exported, rather than continually complain of being exploited. With Ms. Eniola, when she was talking about the agreement which we enter into, should be an agreement that leaves both hands after a shake full, rather than taking from the other and leaving the other empty. So by and large, as we try to round up, we should begin to look at mining and construction as a business enterprise, where the people who produce are actually trying to maximize profit. They don't have to be foreigners. There are Africans in Africa who are businessmen and are exploiting Africans. Thank you very much, and God bless.
Thank you. Please, can I invite the speakers to have their interventions?
So, on mining, unfortunately, Nigeria has been late to the party because they started mining not quite long ago. But if you look at most of these African countries that we have, there are stringent laws that make environmental impact assessment a precondition for your operations. And as part of the environmental impact assessment process, there's something we call public hearing, where you need to even advertise in the newspaper and say that this project is going on. We are having a public hearing about the potential environmental, social, and operational impacts of this potential project. So at that vein, the community is there. And even when, if you look at most of the time, the composition of the panel, that will sit on that whole process. Mostly, you are required to have mostly 3 people. 2 people must come from the community, and the chair being somebody outside the community. So in terms of community participation, it's huge. Now, the question is that when they are participating, do they push for the things that will really protect them as a community? Possibly, I would say it might be no, because in Ghana, we have lithium as well. One key thing that delayed the project was that even lithium must be transported to the port. So they wanted to use the main road. The consideration was that can they build a railway line to transport it so that our roads are not impacted. So there are control regimes to deal with this, with most of our laws. And I don't think Nigeria might be an exception. So I will always say we need to do a lot of advocacy to make sure that people are aware. So if they sit down and say they've granted a permit, now the question is that did they even go through public hearing process? These are the things that we should raise, advocate, and sometimes take it to court to challenge. That the process, they did not follow the required process, and you think that the permit should be null and void. So these are the positions from us as practitioners I think we need to adopt. Other than that, we will not be able to save our communities, and we will always be in court and be in our jacket and suits talking about what the law ought to be, but not why we want the law to act for us. Thank you.
Please, a round of applause for him. Thank you so much, sir. At this juncture, to bring us to a close of this session, we will be presenting our plaques to the speakers. And to help us with this, I would like to invite one of the members of the Governing Council of the African Bar Association, Senior Charles Kihara, to come up to the stage, please, to help deliver the plaque to Ms. Eniola Sonuga.
I think I should make one or two statements. No, before I start the presentation. I thought I need to use this privileged position to make one or two comments. I do agree very entirely with Prince, what he says. I think a lot of it is us implementing the laws. I've looked at the countries. We have all those requirements, impact assessment, etc., etc. And the other thing is the ignorance of our people when they are signing the consents. Sometimes they are signed by a representative of a family who has no authority, and then they are also signed in very, very informal documents. Because at exploration stage of a mineral, people are not sure, people don't even know there is anything. So they usually give away their rights very early. Then the person, after he gets now the exploration, because according to the mining laws that I have looked at, you get an exploration license, then you get the mining license. Now, that is where the link. Now, at exploration, everybody is very cheap. Even if you discuss with the Saudi Arabian how Aramco came in to do the oil, it starts very cheaply when you don't know you have it. Anybody coming around to check around. That is where now the range starts beating us. So that by the time you go to real mining, you have already given out a lot of your rights. Then there was very strong feelings that we don't do value addition, we don't do processing. There are countries that have very good example, like Botswana with their diamond. They have crossed that mile where they are processing everything. They are doing it locally in Botswana, and they charge nearly 75%. The company that does the mining only retains 25%. Thank you. Now, I think with that is my pressure now to... Yes. Hmm? Yeah. Yes, it's my pressure on behalf of the African Bar and the distinguished delegates in attendance to present this token of award of appreciation to Eniola for her presentation. Thank you very much.
Thank you so much, sir. We also want to have you present the plaque to Mr. Prince Osisiadan.
Thank you. Once again, it's my pleasure to present on behalf of the African Bar and the delegates in attendance to present this token of appreciation and award to Prince for his lucid discussion.
Thank you so much, sir. Once again, we would like you to present the plaque to Chief Joe Kiari Gadzama, Senior Advocate of Nigeria, represented by myself, Onyekachi Eluwa. Thank you.
Once again, it's my pleasure on behalf of the African Bar Association, the Governing Council, and the delegates in attendance to present this token of appreciation to the delegate, Chief Jokia, Chief Jokia and the Jokia's Gatama. Yes. It's a pressure for the services that she has rendered in this discussion. Thank you.
Thank you so much, sir. We're grateful. So please, Simon, help us with the photographs of all the speakers on stage. Thank you. Please, may we have a round of applause for ourselves, for the speakers, for those who asked questions. Thank you so much. Okay, we'll just have an announcement right now as we close the session. Thank you.
Thank you. Good people, I hope that the people attending the financial instrument sessions are already here. Is there anyone here to attend financial instruments? Is the chair with us? I would recommend that, Madam Chair, you take charge of the session immediately because we are behind time. Those of us who are here and intend to attend the financial instrument sessions, pick your tea and come back and sit down so that we continue rolling. Thank you very much.
Join us as we are proceeding. I'm going to be the session chair for this financial instrument breakaway session. My name is Mbagwana Anastasia Mtembu from University of South Africa. Today we're only having two presenters. Our first presenter would be Mame Bohima Foucault. Her topic on today's presentation is legal protections for African consumers in the era of digital globalization, comparative analysis of mobile money regulatory frameworks. I hope Mame will be enlightening us on the developments of technology when it comes to issues of mobile money. Over to you, Mame.
Good morning to all distinguished guests here, my learned seniors and my learned colleagues. As my chair said, my name is Mame Bohima Foucault, and today I am honored to be giving a brief outline of my topic, legal protections for African consumers in the era of digital globalization, a comparative analysis of mobile money regulatory frameworks. Okay, can we imagine an Africa where transferring money is simple and safe, where every consumer feels protected and every transaction is secure? This is what my article focuses on. By using Ghana as a case study, it examines the already existing legal frameworks and compares them to countries like Liberia, Uganda, and Nigeria. And the goal was simply to identify consumer protection gaps and ultimately propose a harmonized ECOWAS regulatory framework inspired by the European Union's digital payment system. I'm sure you are wondering how mobile money has improved financial inclusion in Africa. Mobile money, functioning as a digital wallet linked to users' SIM cards, it has basically improved financial inclusion by allowing millions across Africa to transfer, deposit, save, and also withdraw funds instantly without having to rely on the traditional banking system. Yet, this convenience comes with growing exposure to risk, particularly fraud and data breaches. According to Bank of Ghana's Financial Stability Review report, in the year 2023 alone, mobile money transactions reached 1.07 trillion Ghana cedis, which was approximately 88.3 billion USD. However, this growth has been overshadowed by mobile money-related fraud, which has exposed deep weaknesses in consumer protection. Furthermore, according to the GSMA, Africa lost 1.5 billion USD to mobile money frauds alone, attributing to social engineering attacks. These vulnerabilities manifest through distinct patterns of fraud, which exploit weak identity verification and system security. I would briefly examine some examples of these system vulnerabilities. The first common type of fraud is impersonation, and this is where a person pretends to be another for the purposes of deceiving others. And in the context of mobile money-related fraud, it is where fraudsters basically exploit these weak system vulnerabilities and use fake IDs to register SIM cards, or they manipulate others to divulge sensitive information such as their PINs, which we popularly term as social engineering. And the second type is insider fraud, which is where employees within the system abuse their privileged access to manipulate transactions, leak confidential data, and even tamper with the system to reroute funds. Then we have cyber fraud, which is where hackers use phishing or malware techniques to basically gain unauthorized access to mobile money accounts. And last but not the least is agent fraud, which occurs where authorized agents of these mobile money operators exploit the system by inflating commissions through split transactions. Okay, so what does Ghana's regulatory or legal framework says about mobile money? In Ghana, there are 4 key laws regulating digital payment systems, and they are the Data Protection Act, the Electronic Transactions Act, the Cyber Security Act, and the Payment Systems and Services Act. And together, these laws form a solid foundation on privacy and consumer protection. For instance, the Electronic Transactions Act criminalizes all sorts of offenses committed through electronic means, including mobile money-related fraud. And the Payment Systems and Services Act sets clear rules for licensing and regulating service providers, e-money issuers, and deposit-taking institutions. Also, it mandates complaints to be resolved within 5 to 15 working days at no cost to customers. Despite these legal safeguards, gaps remain as to enforcement and regulatory insights. I'll therefore look at approaches adopted by other African countries and compare and contrast them with Ghana's legal framework. So the first country I'll look at is Liberia. And in Liberia, the unique feature is that mobile money operators must seek for authorization from the Central Bank of Liberia. And once they've been licensed, they also have to enter into written agreements with every individual who wants to open any mobile money account. And we go to Uganda, and in Uganda, mobile money operators are mandated to partner with licensed financial institutions and also obtain a letter of no objection from the Bank of Uganda. And the last country is Nigeria, and in Nigeria, the distinct feature is that there are 3 main models on which mobile money operates, which are the bank-led, non-bank-led, and the hybrid model. With a bank-led, this is basically where licensed banks operate mobile money services, extending the traditional banking system. And the non-bank-led is where licensed corporates or institutions, other than deposit-taking institutions, operate mobile money systems. And finally is the hybrid, which is where both the bank and the non-bank-leds collaborate and provide joint mobile money operations. This diversity in Nigeria's approach fosters digital innovation and competition compared to Ghana's system, which is telecommunication dominated, which promotes monopolistic control and limited consumer choice. So my recommendation, therefore, is that even though national reforms, especially in Ghana, is needed, I recommend that we propose a regional or a harmonized regional framework for starters, which would set standard rules for licensing, consumer and data protection, and data security. Now, the European Union has already successfully integrated something like this, so inspirations could be drawn from the European Union's digital payment system. Under their system, the digital payments is governed by the Payment Services Directive, the Cross-Border Payments Regulation, the Interchanging Fee Regulation, and the System European Payments Area Regulation. And under the European Union, each key player has a distinct role to play. The European Commission basically initiates these legislations and regulations, and they have the European Banking Authority, which sets the standards and technical guidelines. And as usual, member states incorporate these directives into their national laws. My conclusion is that ECOWAS can adapt similar mechanisms into its national laws or regional laws, which would enact, and then tailor it to the African context. So if, just as we treat human rights as a universal right, consumer protection in the digital ecosystem can also be treated as universal. Thank you.
Thank you, Mame, for your enlightenment, making us aware about the developments in money, mobile money, how it has strengthened financial inclusion based on the traditional way of banking. We have also made a comparative analysis between Ghana and other countries like Nigeria. You also examined the issues of fraud, looking at cyber fraud, looking at the utilization of fake IDs by people opening accounts. You have also looked at insider fraud, where members of the bank themselves will give out information. You have also proposed a harmonized regulatory framework. May we please give her a round of applause. Our next presenter will also be enlightening us on issues of financial instruments. The next presenter is Hannah Audrey Arthur. Her presentation will be the growth engine, rules that unlock capital, regulating for growth, corporate governance, global requirements. Hannah, just to check with you, have you joined? Thank you. Can we give Hannah a round of applause? Then she can present her paper. Hannah, you can present your paper.
Okay, thank you. So, good morning, distinguished chair, honorable ladies and gentlemen. I am Hannah Audrey Arthur, and I'm very privileged this morning to join the conversation on the general overarching theme of this conference and contribute to the talk on foreign direct investment in Africa with a particular focus on Ghana. So, for this presentation, I will be looking at foreign direct investment from the good governance perspective, looking at entry to impact, what you need to know if you try to, what you need to know if you want to market, basically an overview of the vehicles of incorporation, the capital requirements and equity thresholds, the sectorial restrictions, and also a general discussion of the proposed amendments before the Ghanaian Parliament. And I'm going to end on a bright note with my recommendations in the hopes that Ghana is able to maximize the benefit that come with foreign direct investment, whilst minimizing its adverse impact on the national development and on the local economy. So, on setting the ground rules, the vehicles of incorporation then and now, Ghana has always been a hub for investors. As far back as the 1900s, the first comprehensive legislation on corporate governance and commercial law in Ghana was the Companies Ordinance of 1907. And it came into being as a result of the influx of South African and other foreign enterprises in the country. So for the past century, quote unquote, Ghana has been seen as a favorable environment for foreign interest and for foreign growth. Now, although this first attempt was generally described as dead on arrival because it was lifted verbatim from the prevailing English legislature at that time, towards the end of the 1900s, the new Companies Code, the Companies Code then came into being to try to streamline efforts towards bringing Ghana into the modernized standards of business regulation in Ghana. The Companies Code 1963 did its bit, and the now parent legislature on company law in Ghana is the Companies Act 2019, Act 992. Now, Act 992, apologies, is the Companies Act of 992. Act 992 has brought Ghana into the modern sphere of investment, has brought Ghana into the modern sphere of business regulation. It has introduced for the first time the beneficial ownership requirements, where in incorporating a company, you have to declare anyone who has a stake or some sort of influence over the company, whether or not the person has already been declared as a director. Whether or not this person has already been declared as a director or an owner of the company. The beneficial ownership threshold also differs depending on whether or not this person is an exposed person. The Companies Act 1992 has also scraped the initial minimum capital requirements for local entrepreneurs, opening up the Ghanaian space for locals to thrive. Ghana for the purpose of carrying on business in the country. This leads me now to the business vehicles in Ghana. For someone conducting business in Ghana, you can either operate as a sole proprietorship, where there is no distinction between the owner and the entity. It's a one-man show, the owner bears all the liabilities of the company, or it can be a partnership, which has with a minimum of 2 people, maximum of 20 people. A company can also be, a company cannot be in a partnership in Ghana. The other alternative is a company limited by shares. is a company limited by shares, where there's a separate entity, there's a separate distinction between the company and its owners, or a company limited by guarantee, which is not a profit-making venture, so it's mainly suitable for non-government organizations and non-profit organizations, or an external company, where the entity already exists outside the jurisdiction, but is opening up a branch in Ghana here. And the main distinguishing feature between the external company and all these other vehicles that I've mentioned is that the external company and its parent entity abroad are one and the same. So in incorporating an external company in Ghana, you do not have to, you don't obtain a separate documentation outside of what the parent company has. You submit the parent company's memorandum or articles of association, its certificates of incorporation, its shareholding structure and everything, and you replicate that in the country. Now, for the purposes of foreign investors seeking to enter the country, sole proprietorship does not avail them, and the most common vehicle of incorporation is the company limited by shares or the external company. And the purpose of my discussion, I will focus on the company limited by shares. So, as previously mentioned, the now existing Companies Act, Act 992, has consolidated Ghana's frontier in terms of corporate governance in Ghana by providing a basic underlying framework for all companies incorporated in the country. So before the company can adhere to any other sectorial regulations, generally, as you set up, the Companies Act requires that you maintain certain level of corporate governance by, one, having a constitution. So you either submit a bespoke constitution outlining your company's objectives and your company's procedures whilst you incorporate the company, or in the absence of that, the Companies Act will give you the standardized or the standard constitution, which sets out the basic regulatory framework of how to basically manage the governance in the company once the incorporation is concluded. In addition to this, the Companies Act also mandates that every company incorporated in Ghana as a limited liability company must have a company secretary. And one of the key distinguishing features of the Act 992 is the fact that it has set out particular requirements or qualifications for the company secretary. So you cannot just appoint a random person as a company secretary. The person must be someone with a tertiary level qualification or someone that the board of directors deem that as a result of this person's qualification, he or she can act as company secretary. The company secretary must also be someone who is well versed in company law. So it's normally advisable to have a person who is a licensed member of the bar as the company secretary of an entity, because primarily the function of the secretary is to be the compliance checkpoint, advise the board on compliance requirements, file returns, maintain the statutory registers and other documentation, and ensure that all required filings are promptly done at the Office of the Registrar of Companies. The next bit is the directorship. Ghana does not have the two-tier system. We operate a one-tier structure of directorship, and there is no distinction between an executive director and a non-executive director in terms of their duties to the company. So under the Ghanaian law, Act 992 expressly sets out that the director stands in a fiduciary relationship to the members of the company. You are prohibited from entering into any transaction which presents a conflict of interest or prevents you from discharging your utmost duties to the company, or where your personal interest will conflict with your duties as a director. You are advised to refrain from such conduct. And another statutory requirement is the fact that for incorporation, the company must have at least 2 directors, one of whom must be ordinarily resident in the country for, local compliance purposes. And then there's also the requirement for an auditor. And this auditor must be a licensed chartered auditor in the country. He must be part of an auditing firm, and the auditor will prepare the financial statements of the company at the end of the financial year, vet and certify same before it is submitted to the Office of the Registrar of Companies for the relevant filing. The auditor stands in a fiduciary relationship with the company as well, and he is mandated by law to discharge his duty to the utmost competence expected of an auditor in such a scenario, basically with such qualifications. Now, once all that I've spoken about has been completed and concluded, then the Registrar of Companies will issue a certificate of incorporation. Initially, there was a certificate to commence business in addition to this. That has been scrapped. So under the new regime, we only have the certificate of incorporation and then the company's profile in addition to the company's beneficial ownership structure. Then the company can proceed to operate in the relevant sector of operation, for want of a better word. After this has been done, the moment the company has any level of foreign participation, then the GIPC requirement is triggered. GIPC is the Ghana Investment Promotion Center, and it was established by the Ghana Investment Promotion Center Act. It's the primary government agency for encouraging and promoting investment in the country. Now, the Act specifically sets out initiatives to encourage investors by ensuring that there's a non-discriminatory policy. Investors in Ghana have the same rights and obligations as local business owners, quote unquote. And also there's also the guarantee against expropriation. So foreign investors can come into the country assured that under no circumstances can they be forced to cede over ownership of the company or control of the company to the state or to any other individual. Now, in order to benefit or to operate as a foreigner in Ghana after incorporation, you have to meet the minimum capital requirement threshold. In practice, you declare the minimum capital requirements in line with GIPC requirements before incorporation is completed. In explaining this, so once the company has any form of foreign participation, you automatically have to comply with GIPC requirements. So in registering at the Office of the Registrar of Companies, you have to specifically state the stated capital, and the stated capital must be in compliance with what GIPC states you should pay if you are a foreigner operating in Ghana. You don't have to bring that money up front at the Office of the Registrar of Companies when you are incorporating the company. What you do instead is you pay 1% of that money, that stated capital, as your stamp duty. That money is paid at the point of incorporation. And once the incorporation is concluded, then you move to the Ghana Investment Promotion Center to register. That is when you must show proof that the required threshold or the required amount has been either deposited in a bank in Ghana or has been brought into the country in the form of assets. Now, the threshold states that for a wholly owned enterprise in Ghana, the foreigner must invest at least 500,000 United States dollars in cash or the relevant capital goods. For a joint venture with a Ghanaian company, the foreigner must invest at least $200,000, and the Ghanaian partner must hold at least 10% equity in the company. And for a trading enterprise, which has been defined as basically trading and imports of goods in the country, you need to invest at least $1 million in the venture and employ at least 20 skilled Ghanaian workers. Now, this minimum threshold aside, the GIPC law also requires that foreigners are only allowed to participate in certain areas of commercial engagement. So there are restricted sectors where foreigners cannot operate. And these are market stores or petty trading or hawking. So a foreigner in Ghana cannot engage in petty trading or hawk goods. A foreigner in Ghana cannot hire or cannot engage in a vehicle rental or a taxi business with less than 25 fleets in the company. A foreigner in Ghana cannot operate a beauty salon or a barber shop. A foreigner in Ghana cannot print telecommunication recharge scratch cards. A foreigner in Ghana cannot produce exercise books or basic stationery, or engage in the retail of furnished pharmaceutical goods, or produce or supply sachet water, or engage in the pool betting, with the exception of football pools. So the loophole here is that once you have a fleet of more than 25 vehicles, then you can engage in that particular sector. But every other sector mentioned is closed to foreigners. The policy rationale for this was obviously to protect The policy rationale is to protect the local economy and ensure that foreigners do not come to Ghana under the guise of development and basically end up crippling the Ghanaian backbone. And all these reserved activities for sectors which prevent foreigners from operating are sectors that the ordinary Ghanaians operate in, and it's less capital intensive. So it's also a means of ensuring that only serious quote-unquote investors can come into the country and prevent the influx of foreigners coming in with capital that the locals do not have to operate in a locally dominated sector and basically obtain all the benefits, leaving the locals at a loss. However, in spite of these policy rationales and evident benefits. There's also the counter argument that restraining or restricting foreign participation and only allowing for foreigners with a certain amount of money to engage in the sector ends up discriminating against certain small but innovative firms, which would have actually been quite transformative to the country's development, but are bad because of GIPC requirements. All these discussions led to stakeholder engagement that culminated in the drafting of the Ghana Investment Promotion Center Bill 2024. Now, this bill sought to make certain key changes to the existing regime by, first of all, scraping the reserved sector for Ghanaians. So under the GIPC Bill 2024, there was going to be an open market for foreigners. There was no restrictions anymore for foreigners seeking to engage in certain areas of commercial activities. Additionally, they also removed the blanket provision of the minimum capital requirements because the existing regime sets out certain tiers and the amounts that are supposed to be paid. The proposed amendments scraped the wholly owned, scraped the partnership, and only retained minimum capital requirement threshold for a trading company. And in that, it's also reduced it from the $1 million to a lesser amount. However, due to legislative processes in Ghana, at the beginning of this year, the bill in 2024 lapsed because we had a new parliament constituted. So the legislative process had to commence again. And this time, the introduction was not a bill. It's not an effort to amend the existing legislature, no. The new proposed Ghana Investment Promotion Center Act seeks to replace the existing law. And the positive thing which has been applauded widely is the reintroduction of the reserved sectors. So this bill is presently before Parliament. It's open for stakeholder engagement. Once this bill goes through all the relevant processes and is passed, what it means is that the reserved sector will remain reserved for Ghanaians. However, the bill also affirmed what the previous 2024 bill was trying to introduce by scraping the blanket capital requirements and only maintaining it for trading companies, reducing the threshold from $1 million to 500,000 United States dollars, and increasing the employment requirements by saying that for a company engaged in trading in Ghana, you should employ at least 75% of skilled Ghanaian staff. There is also the exemption for portfolio investments or enterprises which are established solely for export trading. So if you are an investor in the country and you are only, the business of operation is basically exporting goods produced in the country, then you are exempted from meeting this minimum capital requirement threshold. Because the rationale is that this threshold is seeking to protect our local economy. And if you are promoting local made in Ghana goods, then there is no need for you to meet this requirement because you're already doing your bit to support the economy. Another significant development in the new bill before Parliament is the introduction of citizenship by investment. Now, this is novel, never been done before in the country, where the bill, once passed, will have provisions which will mandate the Minister of Interior that, in consultation with the Ghana Investment Promotion Authority, enact a subsidiary legislation which will specify certain categories of investors who will be eligible to apply for a Ghanaian citizenship under defined conditions. We are yet to see these defined conditions, and it's a new provision which has had mixed reactions. Some see it as a way to encourage positive investment in the country, that other nations on the continent and worldwide have done it. It's led to increased investment in certain key priority sectors and areas. The other side of the coin also sees it as a way to bypass the protection for local economies. That in this instance, even though there is a certain restriction on local economies, allowing the foreigners to have citizenship will end up defeating the purpose of the bill. We are still in wait as to how that would pan out, but based on these concerns, and based on the benefit that once enacted properly can give the Ghanaian economy, I have these recommendations. The first is that the protection of local economy must be paramount in all instances. The scraping and reintroduction of the reserve sector is something that deserves applause because it protects our local entrepreneurs. So it should be something that should it should be non-negotiable that regardless of the amendments that come to play, if anything needs to change, it doesn't have to be a total overhaul. It has to be specific, targeted sectorial changes, which will introduce innovation and introduce advancement in a particular sector, and not scraping entirely a restriction that protects the local Ghanaian entrepreneur or the local Ghanaian worker. The second recommendation would be set timelines for amendments. In Ghana, our laws tend to span decades before we see any new changes or any amendments. But for this particular one, and with the speed at which the global business scene keeps changing, it is very, very imperative that Ghana enacts or Ghana puts in place specific measures to constantly and periodically review our laws to ensure that whatever has been implemented but is having an adverse effect on our economy is immediately rectified. The third option is to look at the future, is to look to the future. There should be consistent and specific targets aimed towards improving SMEs and improving the tech market in Ghana. If it calls for enactment that will encourage more foreigner participation in the tech sector in order to develop our local talents, in order to develop the local resources in Ghana, and to boost our Ghanaian human resources so that we can stand on our own feet in terms of that particular niche, then it is something that the government could look at. And my last recommendation, which would be looking at the broader picture, is that we tend to have a lot of discussions on presenting a unified front as Africans, but when we come to the local legislation, we seem to omit this part. So using the opportunity and the platform of the African Bar Association, it's something that we can all have a think about as we go back to our individual countries, that in enacting local legislations, especially in the area of foreign direct investments, care should be given and specific requirements put in place to ensure that we give attention to enactment that are not just promoting our local economies, but are also achieving regional goals and ambitions at the same time. If it calls for particular sectorial provisions for certain countries in the region, so that there's a collaborative effort to boost our capital, boost our development internally without the foreign influence, then that should be greatly encouraged. On that note, I am going to end here, hoping that we all take home the think bit about ensuring that we strike the delicate balance between, one, maintaining foreign direct investment benefits in Africa, and ensuring that in courting these benefits, we don't relinquish our autonomy, we don't compromise our regulatory standards, and we don't end up diminishing and destroying our local markets. Thank you very much.
Thank you, Hannah. Can we give her a round of applause? Thank you, Hannah, for presenting on foreign investment, focusing on corporate governance, the recommendations that you have made when it comes to local government establishing their own regulatory framework when it comes to issues of foreign investment, the thresholds that have been placed in the bill, should it come into play. Ladies and gentlemen, we have come to the question and answer session. Do we have any questions for our two speakers, Hannah and Mami? May we please have a roving mic? We have a gentleman in front and the lady at the back. Please state who you are, where you come from, and the question to whom it is directed.
Hello, everyone. My name is Agnes Sentala. I'm from Malawi. I would want to say thank you so much to our speakers for the discourse that we are having. My issue relates to mobile money. I can't agree more in terms of financial inclusion. It is a game changer. In your presentation, you alluded to the fact that there are several pieces of legislation that try to protect the consumer in that regard. I wanted to get your views if, in your analysis of issues, you feel that insofar as the dispute settlement mechanism is concerned, is adequate. I'm asking this because you agree with me that when you look at the majority who are benefiting from this platform, are less privileged, they wouldn't have the muscle to fight it out in court. Even where it comes to complaining to the regulator, I know like in my country, we have a complaints handling unit, which is championed by the Office of the Registrar of Financial Institutions. You will still find out that even more of them are not that ready to toe that line. I've heard many a times where some have said, okay, yes, mobile money, but when I'm hit hard, there isn't that platform that I can easily interact with to make sure that my concerns are addressed, and not only addressed, but they are addressed with the speed that I would want to see them addressed. So I wanted to have your views on the dispute settlement mechanism insofar as the mobile money framework is concerned, as we try to come up with our standards. Thank you so much.
The chairperson and panelists, distinguished participants. My name is Mohamed Ndayako, Senior Advocate of Nigeria and Vice President AFBA on Budget and Finance. My question is directed at Ms. Mami. What interests me in your presentation is the issue of fraud in financial instruments. And the case of ATM, particularly in Nigeria, there are situations that the holder of an ATM will be in a particular city, and perhaps with connivance from the bank, somebody in another city of about 500, 1,000 kilometers will withdraw money from the holder of that card's account successively, even in excess of the holder's, transaction limits, because these cases abound now in courts, and the victim will be successful in pinning it on the bank, but in some cases the bank will say you compromise your pin, even if the perpetrators are far, far away, and that is one. And even if the original owner of the card wants to withdraw more than the limit, he cannot. But the perpetrators will withdraw in excess of what the card holder. So this is the problem, in our financial instruments in Africa. But I take the case study of Nigeria because we want to do a cashless society. I arrived Ghana on Friday, and hoping that I'll be able to use all my cards. I dollarized some of my cards, and up to this moment, I couldn't use my dollar Zenith Bank card, even though we have Zenith Bank here in ATM. But luckily, the POS, it is working in POS, so that is what I have been using. But I cannot go to ATM, because I want to use CDs, but I have to either use my card, or if I have cash dollar, I then change it to CDs. So these are the problems. So how are we looking at how to harmonize this? We want to do cashless society, our financial institution. But here we have network failures, we are burdened with this fraud and so on. So how do we, improve on what we already have? But the problem is still there, and it's becoming endemic. As I said, a lot of cases are now in court against banks. Thank you very much.
Thank you very much for the question and contribution. So in answering the dispute mechanism question, I would actually agree with what you were saying. So in Ghana, for instance, the Payment System and Service Directive Act sought to deal with something like that. However, they cap it to a 30 days complaint. So you have to report within 30 days. So if you've had any fraud, if you've had any fraud-related issue and you do not report within 30 days, then it means it can't be resolved. And this is a problem. So I think our issue in Africa is trying to promote the financial inclusion more, forgetting the victims. So quite recently, a lot of people have been complaining about, not to mention name, but MTN's mobile money system. And they've sort of tried to push the blame to the victims, making it look like the only way you can have these fraud happen is when you divulge your PINs. But the fraudsters have improved, actually. They've found several means to sometimes they even use the apps. With the apps, apparently there's this backdoor system that they can use through their software and malware functions to gain unauthorized access to your accounts and, like the vice president was saying, withdraw money, sometimes even in excess of what you have. So an issue we have to address is the dispute resolution mechanism. And this is why I think, or my proposal is that we have to have a uniform standard for licensing and regulating these things in Africa. So Liberia's system, for instance, they are very keen on that. With that, they do not even care if the telecommunication market or those involved in mobile money operations are going to move. They have strict standards for suspension, fines, and what have you. So they've even recently suspended one of the companies, and they had to move because they gave them a hefty fine that they could not pay, and it looked like they went bankrupt, so they had to move. So if some of these standards now, it looks like it's now territorial based. So if some of these standards are centralized or universal across Africa, the states would hold the states accountable, and the states they would have no option than to hold the telecommunication or any financial institution operating mobile monies accountable as well. This is one way I think we can improve on that.
Thank you, Mama. I do not see any further hands for questions and comments. If we do not have any further questions for our speakers, we've come to the end of our session. I will then request Mr. Augustine Kekeche to present the plaque to our presenters as a token of appreciation for presenting at the AFBA conference. Can we give them a round of applause? Miss Mama Foko.
Financial institutions, an interesting discussion that we've had today. I would know that Mami is going to have to receive 2 plaques, one on her own behalf and the other on behalf of Hannah. Someone whispered in my ear that you are cooperators in the promotion of financial inclusion and engineering growth. So I'd like to first invite Professor Tukishi, who is the representative of the University of South Africa on our governing council, to come and deliver the 2 plaques, one to Hannah and the other to Mame. So in the order that you please, you can open. If anyone has a designer phone and would like to be philanthropically oriented, to support our process of documenting the awards, please, let's make use of your gadgets. Thank you. Now, she is receiving a second one for Hannah. Hannah is watching. Wave to us if you see what is going on here, Hannah. All right, thank you. Yes. Now, Mohammed Ndak, thank you. Thanks a lot. You are the one awarding this one, so you need to release that camera. Yes. So our Vice President Finance and Corporate Affairs is going to have to award the plaque to Anastasia. Anastasia has done a good job. It's not easy to moderate a session where you have fewer than needed speakers and fewer than needed participants. So thank you very much, Anna.
So, as the presenter of the plaque, I will want another round of applause for her.
The skill of managing two phones to take a photo. All right. Friends, that draws us to the conclusion. We will need a group photo with Professor Tukishi. Mohammed, let's come over here for a group photo. As we assemble, good people, the sessions in this hall have come to an end. This hall is going to close down. The remaining two sessions are all happening in the pavilion down there, where we had the opening plenary. We are going to have a session on the rule of law, and then later a members' meeting. I'm still smiling. Thank you, ma'am. Oh, yeah. You can share pictures now. Okay. Smile is dry. Thank you very much. All right, good people. That's the communication was given to share. When we wind down, we do lunch. From lunch, we then go to the Adesa Pavilion. That's where the remaining two sessions of our conference will take place. The rule of law session will be in plenary, and the members' meeting, AFBA members will have a meeting at 4 o'clock. Thank you. Thank you very much.
For all the times that you rain on my parade and all the